So 6 cases dealing with assault weapon and magazine bans have been relisted, redistributed, and resent to conference once again, causing more delays and even more confusion. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. I had the opportunity to go out to the headquarters of First Form out in Missouri in St. Louis, and it was an amazing time. The company there is amazing. The employees and everybody involved believe in freedom, they're pro-America, and they're pro-Second Amendment. So if you want to support an amazing company and also get some amazing supplements, check them out using the links down below. And thank you again to First Form for sponsoring and supporting this content. As I mentioned in the intro, we need to talk about how 6 cases have now been sent to the Supreme Court once again for conference. They have been rescheduled on a 3rd attempt, I believe, for a conference. And now a lot of people have questions about what is going on. Now, the cases we're going to be focusing on in this video and talking about are 6 Illinois cases which are seeking immediate Supreme Court intervention. The cases include the NAGR versus Naperville case, the Harrell versus Raoul case, the Barnett versus Raoul case, the Gun Owners of America versus Raoul case, the Langley versus Kelly case, and then the Herrera versus Raoul case. So those are all the cases coming out of Illinois that are seeking Supreme Court review. These cases are seeking for the Supreme Court to get involved at an early stage, at a preliminary injunction stage, at an interlocutory stage, essentially step in early and then strike down the state's ban on rifles and magazines that they passed through their new law, which is the Protect Illinois Communities Act, or PICA. Now, like I mentioned, there are multiple cases that are coming out of the state of Illinois that are challenging PICA. Now, one of the cases that we're going to be focusing on in this video, because it's just kind of a good example to follow and track about how all these cases have made their way through the process, that's the Harrell versus Raoul case, which is supported by the Second Amendment Foundation and then also Firearms Policy Coalition. This case started out in a lower court in front of Judge McGlynn, who ultimately did strike down the Illinois ban with a preliminary injunction. The state of Illinois appealed that injunction up to the 7th Circuit, and a 3-judge panel of some of the most anti-gun judges reviewed that issue and then reversed what the lower court said, and they used a type of analysis, which again is that military use test. And it's a type of analysis that should never be used in these two-way cases. In that decision, the 7th Circuit 3-judge panel concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they used the military use test, which again does not align with Bruin, Heller, or any of the Supreme Court precedent. And because of that improper analysis and because of the 7th Circuit en banc panel not willing to get involved in this case, at least at the preliminary injunction stage, that has now led multiple plaintiffs in multiple cases to seek Supreme Court review. Now, in the response, the state of Illinois argues that the 7th Circuit was the first circuit court to consider a Second Amendment challenge to a restriction on semi-automatic firearms or ammunition magazines after the New York State Rifle and Pistol Association versus Bruin case. So one of the main arguments made by the state of Illinois is that the 7th Circuit is the only circuit court to even try to apply Bruin to this whole rifle magazine ban issue, and there's no circuit split right now, and therefore right now at this early stage of review, the Supreme Court should not get involved. Now, one of the other really interesting things with this lawsuit is the fact that the state of Illinois is taking the hardline approach that these types of rifles, essentially AR-15s, that they are not arms, that the magazines in question are not arms, and therefore they're not afforded protection under the Second Amendment. Now, again, that's a very bold position that the state of Illinois is taking. Instead of relying on historical approaches or historical evidence or trying to draw a connection between certain, types of regulations and then banning AR-15s, instead what they decide to do is argue that AR-15s, that the most common rifles out there in the United States today, owned in the millions by law-abiding people for lawful purposes, they take the position that simply they are not arms, that they are dangerous and unusual items, and as dangerous and unusual items, they fall outside the protection of the Second Amendment, and simply that they are not arms at all. And then the state of Illinois also goes on to say that even if the 7th Circuit got the analysis wrong, the Supreme Court should not get involved now, but instead let the lower court build the merits record instead and just simply not get involved. FBC and SAF, along with the other plaintiffs, tried to overcome that hurdle by arguing that even though these cases are at an interlocutory preliminary injunction stage, the court should in fact get involved now, because waiting for the lower court to issue a merits decision based on what the 7th Circuit said, based on their analysis in the military use test, is essentially pointless. The 7th Circuit's military use test is clearly incorrect. Everybody knows it's incorrect. So building, additional factual evidence and records and a merits decision based on that incorrect analysis is incorrect and should not happen. And the Supreme Court should not let that case proceed forward at the lower court Instead, they should get involved now. Now, after these petitions were filed and the response briefs and all the reply briefs and all that were submitted, these 6 cases were then sent to Supreme Court conference, and that happened a few weeks back. Now, during that same conference, the Bianchi Maryland rifle ban case was sent to conference, and then the following week, we received an order list from the Supreme Court, and ultimately the Bianchi case was denied review. So the Maryland rifle ban case was denied review. However, the Illinois cases were not on that order list, and they were not denied review. Instead, they were rescheduled for a new conference, and that happened last week. And so it happened already twice, 2 conferences. We were waiting to see what the order list was this week, and then we saw that the order list did not have a grant or deny or anything like that. With the Illinois cases, they weren't on there. Instead, they were relisted once again. So that means for the 3rd time, these cases are going to go to a new conference this week on June 6th. And they're also going to go to the conference at the same time with the Antioch, New York concealed carry case. Now, this happens a lot in some cases, and a lot of people have questions about what does this mean for the Illinois rifle ban cases and the magazine ban cases, because the Supreme Court denied review in the Bianchi case, but now we're seeing all these Illinois cases getting rescheduled multiple times. So what does that mean? Now, really, this could mean a lot of things. We saw the Bruin case get rescheduled multiple times before the Supreme Court granted review in that case. So we can see that multiple times some big cases get rescheduled and then ultimately are granted review. But then we also saw other cases like the Apache and Bumstock case get rescheduled, I believe like 5 or 6 or even more times than that. It got rescheduled multiple times for Supreme Court conference and then ultimately was denied review. So this rescheduling could mean a lot of things. First, it could mean that a dissent is being written by the Supreme Court, is being written on a denial of Supreme Court review. Maybe a justice or two are taking additional time to essentially finalize their dissents in those opinions. Another option is maybe there is interest in these cases and that some of the justices are simply taking additional time to try to review this issue, get information from their clerks, maybe try to rally some more votes in favor of granting Supreme Court review. One of the other options is simply that Supreme Court is trying to buy some time. Maybe they're pushing this off for later and later conferences until they issue the Rahimi decision. Rahimi is one of the next big 2A cases that is set to be decided before the end of this Supreme Court term. Maybe they know that the Rahimi decision will have 2A references. It's applying Bruin, and maybe it will have implications for a bunch of 2A cases, including the Illinois rifle ban cases and the magazine ban cases. So maybe they're just trying to push the Illinois cases out further and further until they issue Rahimi. And then maybe one of the things they could do if Rahimi has applications to what's going on in Illinois, they could simply grant, vacate, and remand the Illinois cases after a conference, after a later conference, once Rahimi is issued. So that's another thing that could be happening. And one of the last options is simply that as the Supreme Court's term is kind of wrapping up, maybe they're just trying to play catch up. They're not yet ready to address some of these cases, especially multiple cases like this. So maybe they're just pushing off later and later. We see multiple times that at the Supreme Court's end of their term, they will do catch-up conferences. They will issue catch-up orders and kind of just address a slew of cases that they pushed off for later dates because they didn't have time to address them. So that's also something that could be happening. So again, a lot of things that could be happening. I have a little bit of hope for what's going on in Illinois. Again, rescheduling can be a good sign. But again, these are fighting an uphill battle. They're interlocutory cases. They're dealing with preliminary injunctions. They're not final merits reviews. We already saw that the Bianchi case was denied review. It's interesting that it was also set for conference with the Antioch case, but I don't think that they're going to interplay with one another. So we're gonna have to wait and see. If anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.